So what we'll do here is we will work our way through live, and then after a minute or so, well, not even a minute, about 30 seconds or so, we'll work our way through the results of the polling questions into the next slides. About 10 seconds left. So this is a very interesting response and tells us that we have a very good distribution of folks with about 18% that are truly global, but about 40% that operate within the borders of a single state. So as we begin to move forward, we're going to take a multi-geographic view, but we're also going to bring it down into a regional view. And so I think we'll cover most everyone who's on this call. But the other thing that's very interesting to me is the number of about 78% of the respondents are just within the US as a whole. And so even though sometimes we'll talk multi-jurisdictional or multi-geographic, the reality is the states in the US have different laws. So you're really operating across jurisdictions, unlike the European Union that has, for the most part, a single common law. So to set the stage here, what we're going to do is we're going to talk a little bit about why you should care, why we do care, and then we'll move on from there. So Stuart, you want to take this one?
Sure. Thanks, Robert. So starting really at the bottom, thinking about that regulatory obligation, there are a number of laws, as Robert's already mentioned, that do come into play here, whether it's on a state-by-state basis, or indeed, if we're thinking about it in the United States, sectoral driven, such as HIPAA. Of course, just because you're here in the United States and maybe your company's location is just in the United States, doesn't mean that always other laws such as the GDPR won't apply. If your business is targeting residents inside the European Union, you could indeed find yourself having to think about those requirements as well. And the regulatory obligation part, that's somewhat the easy piece. It's the law, we must do it. But the ethical and social obligation part, for me, is really particularly interesting. When we think about the ethical obligation, for me, that takes it back to privacy or privacy being a fundamental human right. It's very much part of that universal human rights under the Article 12 of the Universal Declaration of Human Rights. But if you go to other laws across different parts of the world, they will very much see it as embedded into their day-to-day. The next part that you get to, though, is that social obligation. So fine, it's the law, you have to comply with it. Fine, it's an ethical obligation. But really that interaction with your customers, your employees, and your end users, what are they expecting you to do with the data? How do you build that trusted relationship that you're maintaining that choice and control with them so that they're able to tell you, I don't want to hear, I do want to hear from you, how are you protecting my data? That's the social obligation that we talk about here. And there's a plethora of research and studies that really show that when you get that social obligation right, you drive much better customer engagement. Robin, unless there's anything else you'd like to add, then maybe we can jump to the next one now.
Hang on a sec, working on it. I
think you went backwards.
Yeah, I know. There we go.
There you go. So yes, and so now, is it all of a sudden such a big deal? Well, any of us who's been working in security and data privacy for quite a while knows that this has been a topic of conversation for a lot of us. But the conversation of privacy has become much more focused over the last 5 or 10 years or so. And on this slide, I think there's a number of real reasons why and what we can think about as to why the shifting landscape of data privacy. One, the technology evolution. Obviously, we are using technology at much greater rate to help scale our organization, to help scale the different services that we use. And as a result, we're looking much more at the way that we're collecting and using personal data or personally identifiable information. The concept of state of art, as I mentioned here, is an evolving term. We are using much more things like artificial intelligence, machine learning, things that we wouldn't have previously talked about, but in normal day-to-day business processes. And that brings both new risk and new opportunity. The regulatory evolution, as we've talked about very, very briefly, you've got aspects like the GDPR, CCPA, state-by-state laws. There is definitely a rising tide of how you look at privacy legislation across the globe. As Robert mentioned at the beginning, I've been fortunate enough to help roll out privacy programs across 6 continents. Every law has its own nuances and its own shift. And so while a lot of companies will use one as its baseline, you have to be thinking about that shifting regulatory landscape. The third aspect is that data subject demand. So data subject, very much a term taken from the EU, but really to mean an individual, whether it's a patient, a customer, a consumer, an employee. They're very much more attuned to what are their rights and what are the things that people are doing with their data, or companies are doing with their data. So the expectations and the demands of the individual are becoming much more crucial and heightened. The operational complexity. The regulatory environment, as it keeps growing, as we've mentioned with the technology piece, our business operations have also grown. We're using data for many more purposes and many more insightful reasons. That brings in that additional regulatory landscape and the additional controls that we must think about. And then, of course, finally, the span of leadership. If I think about my own reflections on programs that I've rolled out, and the role I play right now as VMware's Chief Privacy Officer, you don't always have a full team to be able to do things. You have to grow influence across different business stakeholders. So how do you bring together all of those different conversations? How do you bring together all of those different actors to really help you achieve your goal? And being that orchestra conductor across a series of chairs across the organization to help you achieve a common goal is really a big task, and one that's increasingly important for people in my role, and indeed in many of your roles working in information security and privacy.
So as we begin to talk about data subject demands and we move on into a regulatory environment slide, one of the things I wanted to draw to your attention is there's a cultural difference here too. So if you think about Europe, you go back into World War II, and what were people persecuted, prosecuted, put to death for, put in jail for? Race, ethnic origin, political affiliation, trade union membership, health status, sexual orientation, et cetera. So a lot of the European privacy laws have grown from that, and then California has kind of taken a lead from that. But you have to be aware of history, you have to be aware of politics, and you have to be aware of not necessarily what's directly identifiable, but also what is indirectly identifiable. So as an example, toll tags, right? Or as an example, smart meters on your house of knowing when people come and go. So a lot of the laws now are talking about directly or indirectly identifiable about an individual themselves or a member of their household. And as we begin to go there, then the definition of breach has expanded quite a bit. So what we did here is we tried, just from a graphical standpoint, to overlay a number of the recent laws, rules, and regulations. So we have the California Consumer Privacy Act, the California Privacy Rights Act, which is the follow-on to the CCPA. We have the brand new Virginia Consumer Data Protection Act, which just passed, I think, 2 weeks ago. And then, of course, we have the General Data Protection Regulation out of Europe, which went into effect in 2018. So the point here that we're trying to illustrate is there are a lot of data subject rights, right of access, right of deletion, right of data portability. All of those kind of overlay into the bulk of these laws, rules, and regulations, and that's a fundamental change. But also, why there's a lot of commonality, there's a lot of disparity too. And so organizations that are trying to understand the global environment of privacy, or the regional or the state-based and the local-based version of privacy, what this slide is really driving is that you must be aware of all the regulatory environments in the jurisdictions in which you operate, and you must be aware of how the data subjects or the individual whose data you are processing may react to that. So with that said, we're going to move down into some definitions here. So we just want to separate a little bit of information security from a little bit of privacy. So as we look at security, what we're really talking about is best practices, leading practices, as it results to attempted or proven penetrations of an electronic or automated system. From a privacy perspective, we're really talking about a regulatory environment. And the term breach and incident are defined in law, rule, and regulation. So what we will oftentimes say is that most privacy breaches are the result of a security breach, but certainly not all security breaches are a privacy breach. And one of the things to remember is some laws talk about electronic data only. Other laws talk about paper and electronic. So when we talk about a privacy breach, this could be as simple as a bunch of HR records that are tossed into a dumpster. It doesn't have to be a system. So the key here is that information security and privacy have got to be joined at the hip, and they have got to be moving together and forward together in both the security and the privacy plans and remediation for an organization. When I first became a privacy officer, I walked into information security and I said, we have to encrypt. We just absolutely must encrypt. And the chief information security officer told me to take a hike. And he says, that's 2.5 years from now, and I'll get there when I get there. Well, that environment is over, and we aren't seeing those types of discussions anymore. Rather, both information security and privacy are being held accountable for regulatory obligations, and that's a huge change. So polling question number 2. So as we get ready to go into breach, the question here is, how would you rate your breach readiness? And we tried to put a couple of words to explain each of these. And this is a big deal, right? So as we begin to talk through the rest of the presentation, we'll kind of think about things in this particular way. The ad hoc and the repeatable or limited are probably the least mature states that you would expect to see from a privacy perspective. This means you may or may not implement a privacy incident response plan, and that may or may not be repeatable across the organization, i.e. if something happens in HR, that doesn't necessarily mean the same thing will happen in marketing. Now, we're thrilled to see that about 43% of the companies are at the defined and managed level. This means that you have a formal plan that's fully implemented across the organization, and you audit the results of that plan. So this is a great representation of what we see in the marketplace, basically 50%, 50%. And part of this ties to how close your information security plan program is to mature, as well as how ingrained privacy is into the organizational culture. Stuart, I think the next one is yours.
Absolutely. So you, one more please, Robert, thank you. So yes, so when we're thinking about the causes of incidents or breaches, there's 6 areas that we can really start thinking down to. So the first one, looking at whether it's an intentional or unintentional, thinking about whether it's the insider threat, a disgruntled employee, and there's various examples of where a disgruntled employee has caused or led to a data breach. Or it's unintentional, a human error. It's a misdirected email, it's a clicked on a link, there was a phishing attack, something along those lines. Very much on those social engineering aspects. You also see things these days that aren't always necessarily through obvious routes, like phone calls, where somebody is calling up your front office, your front desk, asking for information to be able to then perform further social engineering attacks, so phishing attacks with a V. You're also seeing much more attacks taking place through SMS and text as well. Then you've got to think about the potential risks from your suppliers and your vendors and other third parties. That offers another threat vector for somebody to be able to get into your infrastructure. If you haven't done a good job at looking at your third-party risk management, you may have a risk there that may lead to an incident or a data breach, or if they are processing data on your behalf. Then we've got to think about the executive and a board level attention to the issue. Much like how we think about the individual or the end user having breach exhaustion because they keep getting a data breach letter, think about your board and how you're communicating these issues to them. Are you escalating the right things to them? Are you escalating things to them at the right time? And we'll get into that in a little bit more detail as well. Then, of course, as Robert's already mentioned, you've got to think about your technical and organizational safeguards. Robert referred to encrypting all of your data, which today for many is seen as a fundamental core entry-level control. It also helps with the safe harbor to some extent with a safe harbor encryption perspective, but making sure that you have those state-of-the-art controls to prevent those incidents. And then, of course, the loss of trust, the loss of shareholder value when you think about the impact of a data breach. The reputational damage, the impact to your brand can often be much more than actually losing the data in and of itself. And then you've also got to think about your data breach notification requirements. As we'll get to later, there's a lot of different requirements across jurisdictions, both here in the United States and indeed globally. Being able to identify what those are and the proper notification mechanisms are key, and often can get pretty complicated pretty quickly. The final point on this slide, of course, is making sure you have that plan. You've implemented a plan that you've tested to mitigate some of these potential vulnerabilities. It's always an if not but when situation. So you need to test that plan. You need to develop that organizational muscle to be able to respond effectively to an incident or a breach as and when it does occur. Robert, do you want to jump to the...
Yeah, and I just want to come back to the executive and the board level that you mentioned. I've been chief privacy officer of 3 different US divisions of pharmaceutical companies. I've worked with multinationals. Stuart and I have worked across biopharma, med device, tech, telecommunications, media, manufacturing, consumer products, et cetera, et cetera. I will tell you, even as recently as pre-GDPR, like 2016, getting to the board level for your privacy program was near impossible. Now we are seeing a lot of boards who I would call are rabble rousers, and they're really worried about the shareholder value, fiduciary responsibility, and personal liability. And that in many cases is driving an increase in the privacy and data security programs. One of the things that we have to remember, though, about many of the breach concerns is that, particularly if you think about the stories that you've read in the paper associated with COVID, the people breaches really are a side effect of what's really going on. So a lot of people will, or a lot of the news will focus on attempted penetrations or penetrations to get to the keys of the kingdom, as I refer to it, which may be recipes for creating certain pharmaceutical products or board notes or M&A plans. And breach of personal data or the inability to prove that personal data was not accessed and not lost becomes absolutely critical. And therefore, it's not infrequent that you'll end up reporting a breach when you don't know if a breach has actually happened, because the core target wasn't the people data. The core target was, in fact, the keys to the kingdom of the organization from a business perspective. Stuart, I think this one, we're going to talk a little bit about what data is worth.
Absolutely. And I always find this slide particularly interesting. I think in many ways, we always have an instinct as to what we think our data is worth in terms of sales. And many are often surprised that when you look at something like banking logins, it's worth $35. It doesn't seem like a particularly large number. And that's often due to the degree of security controls that are out there now. And then you look at something like infant child data and it's $300. And well, why is that? Well, it's because they have a clean credit record. It's because nobody has used that social security number. It's brand new, and it's probably going to be, depending on the age of the infant, it's probably going to be a good period of time before anybody even notices. So there's a real value in that data. And then you get to the far right-hand side when you start looking at US driver's license and passport information. That can often lead to identity theft as well. So that information has a lot more value. Yeah, so I always just find those some interesting anecdotes, because as Robert's mentioned on the previous slide, sometimes the personal data is not always the target of the attack, but there are instances where we can see there is a lot of value in going after certain assets, which makes it, of course, very important that when you think about protecting your information, you're doing that risk-based analysis to understand what data you have and what potential value it could have to the hacker.
Yeah, another one that's not on here that is fairly valuable is health insurance number. And if you think about today's day and age of COVID, the amount of money to get a valid health insurance number has gone up because of the financial implications of healthcare, particularly in the US. I saw an article yesterday that said the folks in England or the UK were absolutely shocked during the Meghan and Harry thing with Oprah about the number of pharmaceutical company advertisements that were on that particular show. That's because pharmaceutical ads aren't permitted in Europe, but they took the show as is, displayed it. And so we have a whole different environment, and having access to that health insurance number, particularly in the US, is critical. Stuart?
I think we have a polling question now as well.
Have you received a breach notification letter in the past 12 months? And I think we're pretty stable here. Interestingly, I've received 2 in the past week. So I would fall within the 10 or greater envelope. And this is getting worse. And just kind of as a side note, we were having a conversation earlier, but when I get an email about a breach or I get a letter about a breach, I pretty well just toss them. I have to protect myself differently. And the reason I have to protect myself differently is I've been breached so many times that my data is out there. So I have to come through the back end, like credit monitoring, credit protection, things of that nature, just because I know I've been breached. The other thing with breaches is if you get 2 letters and you put them together, you can begin to see, when we talked about indirect identification, certain things. So as an example, the US Office of Personnel Management was breached a few years back. That tells you everybody in the US who has a security clearance. And then shortly thereafter, another airline was breached. And then all of a sudden you could see where people traveling to a country with a US security clearance were noticed. And so they could tell everybody who potentially might be a government employee because of that breach. So this is where we begin to think about what could be and the implications. So when you begin to respond to breaches, you have to think about the implications of breaches from the individual's perspective and not just what the actual breach is. Stuart, you want to take this one?
Sure. So we've talking a little bit here about the lessons that we've learned from the data breaches. A lot of this information is out there. Obviously, we've not named any company names. But there's a lot of lessons that we can learn by looking at what's kind of going on in the broader market over the past 5 to 10 years. As I mentioned earlier, it's incredibly crucial to make sure that you've assessed the value and the sensitivity of the data that you have and that you collect. We showed that slide with the dollar amount on there, but there's often that point of the escalation. What can go on further from that? I think about an example that I saw in the past where you saw a pretty low risk attack actually manifest into something far greater. The escalation of privileges that occurred from there on in actually led to a bigger impact upon a company. And so making sure you've assessed the value and the sensitivity of the data and then what somebody could do with that data is an incredibly important part of your data breach journey. Making sure you have a well-prepared breach response plan. It is incredible how many times people haven't ever looked at what is in their incident response plan, that it's up to date, that there aren't necessarily the right people on there. When an incident happens, and it's always going to be on a Thursday night or Friday morning, usually before a holiday or vacation of some kind, you're going to all be pulled into a room and you're going to want to have a plan that is ready to go, that's been tested, that you have some form of muscle memory, that you would know that you have the right escalation paths in place. That can often save you a lot of time and a lot of frustration when you're trying to navigate a situation which is pretty fluid in nature. Implementing and maintaining adequate security measures is incredibly important. As Robert mentioned earlier, from an encryption point of view, that can often save you from whether having to notify, or if you do indeed notify, that you can explain what security controls in place. And that's where that partnership between your privacy team, your legal team, and your information security team is incredibly important. And then as well, your third parties are secure. What due diligence have you done? What flow down controls are there in your contracts? How are you testing your third parties to make sure that you have good breach response plans in place? Some of the leading practices I've seen in the past is that there would be a regular meeting with the CISO from one organization with the other, so that they could go through how they would handle some form of attack, a zero-day exploit, for example, so that they were testing each other's incident response plans and building that organizational muscle memory. It really provides you that comfort to know that your suppliers are thinking about these things and taking these things as seriously as you do. Of course, as we go through all of these, there are other lessons learned. Robert, was there any others that you would like to share on top of those 4?
Yeah, so number one is we aren't beginning. I personally feel like mergers and acquisitions have increased over the past couple of years, particularly as companies have gotten into financial trouble because of COVID. at least one of these breaches, and by the way, you can just go online and search these out. We didn't want to name folks, but you can just go say data breaches learned, and you'll learn all about who these folks are. But inheriting a breach, or I'm sorry, inheriting a privacy problem as part of a merger and acquisition is becoming more frequent. And particularly when the security controls of the two organizations are significantly different, or the privacy programs of the organizations are significantly different. And we are preaching, and we are beginning to see much more involvement of privacy in merger or acquisition due diligence than ever before, because again, of the board and concerns that I referenced earlier. The other thing I wanted to add here is that when we talk about assessing value and sensitivity of data, breach response plan, security measures, and third parties are secure, all of those are regulatory obligations under the new laws, rules, and regulations. You have to do these. These are no longer best practices. These are regulatory requirements, along with a zillion other things. And it's these types of requirements that are growing the maturation of a privacy program.
I think before we move on, Robert, the other thing to kind of call out here in terms of good lessons, in addition to that breach response plan, get my words out this afternoon, is making sure that you have a good communications plan as well. Because the minute that that breach is notified to whether it's a regulator, if you do it through the media, or if it comes out through other sources, you're likely to have your phone ringing. And so how are you answering those phones in a way that shows the individuals that you are managing this, you're taking this seriously? That's often an overlooked aspect of bringing in that comms team. And we'll get into that a little bit, but it really is a good lesson learned of thinking about that communication aspect. The other part that I'll add, and again, we'll get into more detail later on, is how are you working with law enforcement? I believe now, but Robert, keep me honest here, that often there's requirements that you don't pay necessarily for ransomware. Indeed, I think some of the regulatory authorities have come out and talked about the actual implications of behaving in such a way or doing such an activity. So making sure that you know who your local law enforcement point of contact is, whether it's your local FBI field office, your attorney general representative, so that you can have that relationship in the event that something goes on, that you're not opening up another risk exposure for not handling the breach effectively.
Yeah, exactly. And we'll talk a little bit about members of breach teams in a few minutes, but that also involves retainers so that you have folks on the ready, no matter when this occurs. And you don't want to be training after the fact. You want to be ready before the fact. So next polling question. Has your organization conducted a privacy breach tabletop exercise in the past 24 months? So what we're seeing here is not uncommon, but basically most folks in IT will have heard about it. Not everyone would have participated, but most folks in IT would have heard about it. So if we take the I don't know and the no, then you're sitting at about 69%. The good news is about 31% have. We purposely put 24 months in this to avoid the perspective of the COVID implication, but because business has been so significantly disrupted, but it's also a prime time to try and do something like this, because as you begin to see about to experience business disruption, this will also be when the bad actors are most likely to take advantage of the situation. Stuart, preparing for a breach?
Absolutely. So we've gone over a couple of these points a little bit already, but I'd like to dive into more detail. So the first point is plan. Make sure that you have that incident response plan in place, both from a privacy and a security perspective. Often, I think, Robert, casting our mind back to our previous lives together, we would often walk into an organization and there would be a pretty decent information security response plan, but it didn't consider the privacy angle aspects of it. It didn't consider how do you get involved with the legal team when you're going through some of these situations. And indeed, it often didn't think about the notification requirements. So making sure you have your information security response plan that includes privacy, or a separate privacy response plan that dovetails into your overarching enterprise response plan. It's really, there's different ways you can do it, but at least you have the plan in place so that it's written is the most important thing. The other part of it is socializing it. It's all well and good that you have your top 10 individuals who will be working as part of the plan, as part of your incident response team. But what if they're on vacation at a conference, whatever it is? You need to have a defense in depth type mindset to who is going to be the backfill for that response plan. So having that deeper understanding of who else can be involved and the backups. But also, if something happens to someone in an office in a different part of your company, they know who to call. They know they have a single email address, or there's a phone number. There's a way to escalate it. So as part of your annual cybersecurity training or your annual privacy training, making sure that you communicate that plan as well. I mentioned about designating the response team, your core and your ad hoc members. The other part that I would call out here is who are your escalation routes? And we talked about this earlier with the board stakeholders. So that escalation matrix is crucial, because when you're sitting looking at an incident and as the information is coming in, there comes a point when you're going to say, do we need to notify the next person up in the organization? Or when does this become a crisis? That evolution from an incident to something that we've no longer got control over, then you have to trigger your crisis response team. So making sure that you have that clear escalation matrix, the routes to escalation, the SLAs, the type of incidents that should be escalated, but those are core parts of your response plan. And then, of course, as Robert mentioned earlier, making sure you have those outside retainers, whether it's with external counsel or communications response team or an incident response team that can come in and help you resolve these matters. That's another core part to have as part of your plan. Then, once you got all that in place, you got to practice. And that doesn't just necessarily mean that you throw it away in the drawer and that you wait for 12 months before you dig it out and you do your tabletop exercise. You should be practicing each time you have that event, that incident. You should be going back, you should be reviewing, and you should be updating and refreshing. That way you're always keeping it fresh. In addition to tabletop exercises, you should be thinking about war games. So bringing in a degree of intensity to what you're trying to achieve. A good one we always talked about was you do your war game on a Friday when people are already thinking about the weekend. You've got to get them dialed in. Or you bring them in first thing on Monday morning when they've already got the emails flying in and all the other priorities, but they have to dial in the attention and think about what they're doing. And those can be scenario-led, scenario-driven. I've seen teams use external groups to help them with that, but it moves it away from something that's just a page-turning exercise to something that really gets the heart pumping in terms of an effort. And then, of course, making sure that you are following up on the gaps that you identified as part of your practice. And with quick succession. You don't want to wait until you have an incident that you didn't plug as part of your review. You want to make sure that you plug those gaps as soon as possible. And then, of course, finally, performing. So when the incident does happen, there's no reason to throw that breach plan out of the window. You've got to make sure that you're executing against that plan, because in the event that there are any questions or audits or investigations as to what you did as part of that effort, they're going to want to see that you have followed your plan, that you have gone through and followed the steps that were set out, that you have thought carefully about what steps you're taking. Now, of course, as I mentioned, after you've gone through that performance of a data breach and you've come out the other side, that's when you do need to do that lessons learned, that analysis, and update your plan accordingly. Robert, was there anything else you wanted to add to that?
I was in a conversation with a chief technology officer this morning. He reminded me of a fourth P, which is politics. So, among all of this, you have to keep in mind the politics of the organization, who to involve when, whether it be the general counsel, the chief of corporate communications, the chief of human resources, the chief financial officer, whatever. You have to always keep in mind the politics of the organization to ensure that as these things are escalated, that you do them appropriately.
Yeah.
So downfall, Stuart?
Absolutely. So I think these are some things that we've all seen as we've gone through various incidents over time. The first one is that lack of internal communication. If you don't communicate well about what are the impacts of this breach, or this breach has happened, You often lead to misunderstanding. You don't get the right people in the room. It really doesn't lead to a gelled response from your organization. The piece of paper with dust, as I've mentioned, just because you've got that plan in place, you've got to keep it fresh. It's got to be something that you review regularly and make sure that it holds up to scrutiny. Keep connected with your privacy team and your security team. If you're thinking about, great, we've got that incident response plan, it really covers a lot of the cybersecurity type matters we think about. Consider whether the privacy team is ever in the room or ever in the conversation. Having that relationship for me has been crucial as I've gone through my career and working with others. Clear handoffs, making sure that incident response plan has got the escalation routes, making sure you know who's in charge, making sure you know when you're in charge. If there's something that comes up that involves personal data, who takes charge? Is it the privacy team? Do you bring in outside counsel at that point? Really recognizing that the who takes charge at that point is going to be important for you to be effective in the delivery of that. That plays into that legal privilege angle as well. If you want to assert privilege, you need to bring in counsel to help you do so. And then making sure that you have good training. Often we'll see that you'll have a crisis, but nobody really knows how you're going to communicate that crisis internally and externally. Making sure that you have messaging that you can prepare in advance or utilize standard templates, routes to communications are very, very important. And the only other thing that I'll bring on here, because I notice we're getting short on time, is making sure that you think about what's the right thing to do for the individual that you're serving. If it's your employees and it's an impact to your employees, making sure that you're communicating with them early and often so that they know you're taking this seriously, as well as your customers. You make sure you're providing that clear transparency as you go through this process. Robert, do you?
Yeah, so I'm going to skip the slide on good communication because I think you covered it very well. But again, you know, when I was a chief privacy officer in industry, I had outside counsel on retainer, outside breach counsel on retainer, as well as outside privacy counsel. But breach counsel was the most important. We had outside crisis communications and we had outside forensics. Those three we kept on forensics, on retainer year round. And we also conducted training on the crisis communications. So I'll let everybody read through that. But what you want to do is to avoid the gotchas, and many of those gotchas are covered in this particular slide. Stuart, this one on who to contact because of the internal efforts that you're currently undergoing or that you have been undergoing the last couple of years as you begin to dial in your program.
Absolutely. I mean, obviously we mentioned about the C-suite and the escalation and knowing when to engage your executives, your senior leadership to help move those changes. But I think for here and for the respect of time, legal is often a group that is left out of the conversation until things have moved far too far along. Especially if you're thinking about having to assert privilege, you want to bring legal in as soon as possible. And then your communications team, as we've talked about, it really is important to think about how you're managing those communications. From the external side, obviously the impacted individuals is critical, but who are the regulated authorities and the agencies, the regulatory authorities and agencies that you need to be thinking about? In the US, if you have a data breach involving all 50 states, that may be 50 different states that you're having to notify to, and they will have their own individual templates or processes or timeframes, which in and of itself becomes a difficult task to manage. So that's again when your legal team can really help navigate through that situation.
Yeah, it's a very interesting process as we go through this, and I'm going to flip to slide 32 real quick, because when we're talking about holding these exercises on Thursdays and Fridays, you can see here that there is no real consistency about the breach notification process and the communication process. And Stuart mentioned a while ago, in some cases you have to notify this or that, or some cases you have to notify people within certain timeframes. But here, this chart actually indicates either a regulatory obligation or an obligation to notify the folks. And it can change whether you're what we call a data processor, as in someone who processes data for another company, or whether you're the data controller, i.e. those whose direction you're pulling the data in to process of. So when you begin to look at all of this, you really get down into, if you have to notify in Idaho or Georgia within 1 day, you don't want to be telling the folks in California in 20 days. Or you don't want to be telling the folks at the Office of Civil Rights under HIPAA 60 days. So the whole point is your breach response has to be consistent, and you have to treat all states, all jurisdictions, and all people equally, because if you don't, you're going to run into more problems than you know what to do with. Stuart, so what do we do on an incident response plan?
Sure. I mean, the first thing you've always got to be thinking about is containment. You've got to make sure that you're understanding how you're going to stop or fix the leak, if you will. This is your first priority, is the first page in your plan almost. Your next part, equally critical, is assessment. Understanding how complex it was, whether it's an incident or a breach, did it involve personal data? As Robert alluded to earlier, sometimes that's not always so easy because it may not be name and email address. There may be other unique identifiers in there that may trigger some form of notification requirement, particularly as you're working in jurisdictions outside of the US. And that's when you can start also working out who you need to notify and how quickly. From a notification point of view, I think Robert's already talked about that pretty well, but making sure that you're notifying your internal and external stakeholders and working to start following those templates to notify external parties as well. And that's when your remediation truly begins. So you've contained, you've assessed the impact, you've assessed the data involved and who you've got to talk to, and you've done that notification. Now you're actually taking the action to start remediating everything that's gone in from there. And now you're documenting. And I would even say that even after you've documented and you've had that post-incident discussion, you really should be training, whether you're training the person that caused the incident or the group that caused the incident, or your incident response plan, or team members, if you found that there was latency in your process. That training part is an important post-lesson learn, because then that muscle memory feeds back into how you do containing, assessment, and notification when these events occur again.
Yeah, and this all ties back to what Stuart was talking about earlier about the orchestra conductor. When an event happens, you can't have a fight about who's in charge. The reality is you need to know if people data was involved, and if people data was involved, then a different process kicks into play. Certainly IT has a significant role, but this also comes back to what I said about privacy and IT or information security being joined at the hip. The reality is they should be a single plan that branches off into two different directions, but both those folks have an equal role. And the thing with privacy nowadays is it could sit in compliance, it could sit in legal, could sit in HR, it could sit in marketing. So as you begin to look at privacy, a lot of those don't have the ability to establish privilege or even to execute contracts, and you begin to have to worry about that, which is why this whole incident response plan play and the tabletop stressors of an incident come into play. So analysis and documentation is very similar, whether it's a privacy breach or whether it's a security breach. And what you want to do here is you want to not only track it, but look for patterns. And there are companies out there that are actually reporting this under their external websites now to talk about breaches, to talk about training, to talk about things like data subject rights, data subject access. So you as a company have to decide what your culture is. And as you decide what your culture is, then walking the talk and doing the right thing for the right reason, which is not always the same in every culture, but you can read through this particular slide. Where to report changes based on jurisdiction. This is just 3 different examples, and you can create your own. There are very few places that say you have to use our form. But I will tell you that if you are requesting a consultation or if you're responding to a breach in Germany, you'd better be able to do it in German, or France, you'd better be able to do it in French. And Canada, you'd better be able to do it in 2 languages. So as you begin to think about the jurisdictions you operate in and you begin to think about your reporting capabilities, you also need to think about the language of use and how that will make a difference in your ability to work with the local regulators. And as Adam said earlier, to talk about a defensible program. You haven't heard Stuart or I use the word compliance or compliant program. You've heard us talk about defensible programs and the ability to be able to defend the state that you and your operations are in. So we threw a few resources in here just for information. Again, you'll be able to get this deck by virtue of having been part of this presentation. And I think at this point, we want to throw it open to some questions and answers. I know we have a few minutes left. And of course, our contact information is on the presentation page, and we'd be happy to talk to you separate.
Yeah, so far, no questions have come in during the event.
So we still have people who stayed in.
Yeah, of course. Good. It looks like there's no questions.
So Adam, I'll let you wrap it up then.
Sure. Did we stop sharing, or Robert, you stopped sharing? Yeah. Yeah, so I mean, thanks everybody for attending. You know, we have the link. This will be posted for the presentation. I hope today has been informative, and it's not only a chance to kind of learn a bit about privacy and breach, but also a little bit about the team that's delivering these services. You can see we have a wealth of information. So if you have questions around your privacy programs, there's tons of technologies coming out to help support all the things that we've talked about. If you'd like to kind of learn about some of those, or just whatever, you can, reach out through us, and we will set up workshops or have one-off conversations, whatever you would like. But we really appreciate your attendance. All right. Thank you, Stuart, for joining us. I really appreciate that as well.
You're welcome. Thanks for the opportunity. Really appreciate it.
All right.
Take
Have a
care.
great day.
Be
Thank you.
safe.
All right.